I think it's 5-5, 5-4. We will start. Are you sure? I think Ayush.
Ayush says that he's on mute.
Ayush, you are there?
Hi, good evening, everyone. I'm here. Thank you for.
Yeah, Devan, I think Ayush is also there. We can start the program.
Yeah, we can start the program.
Yeah, okay. Friends, welcome to the webinar organized by Mehta and Mehta Insolvency and Restructuring LLP. So it is a masterclass on insolvency and bankruptcy code, relevant provisions, case law, proposed amendments, and disciplinary. This is session 3, an initiation of corporate insolvency resolution process by corporate applicant, generally referred as section 10 application. And today's our panelist is Advocate Ayush Rajani, Managing Partner AKR Legal. Welcome, Ayush. Thanks for your time. And to formally introduce Advocate Ayush has over 18 years of professional experience in transfer pricing and international tax and expands to IBC since January 2017. He was previously associated with Deloitte for over 7 years. In his initial day before setting up his own practice, he is a managing partner of AKR Legal. He is a fellow member of ICAI and a member of Bar Council of Maharashtra and Goa, and also holds bachelor's degree in commerce. Advocate Ayush has been providing services to financial lenders as well as corporates under IPC. He has been advising and resolution professional from Big Fours and other IP entities, representing the RPs before Honorable NCLT and Honorable NCLT and others as process advisor throughout the corporate insolvency and resolution process, and represented before NCLT and NCLT with regards to complex issues, including resolution plans and forensic application. We have assisted RPs and lenders in over 1,200 matters. Advocate Ayush have co-authored book on IBC law practice, first edition published by Bloomsbury in February 2020, while the second edition is also published in March 21, with third edition published in March 22, and a second edition has been published in May 24. He has also represented RPs in leading and continuance matters involving exposures of 2,000 to 11,000 crores and more before Honorable NCLT and NCLT, and assisted RPs and liquidators in resolving various issues. He is a regular speaker at Income Tax Department, Indian Institute of Insolvency Professional of ICAI, various study circles. Welcome, Ayush. Thanks for your time. Thank you.
Thank you, everyone. Thank you, ma'am, for having me here. It's an honor to join this panel.
Thank you. Our moderator is Mr. Devang Thakkar. Devang Thakkar is also with 30 years of experience in finance, secretary compliance, corporate legal consultancy. He is bachelor's degree in science and diploma in system management and masters in financial management from NMIMS. And he has completed his professional qualification, including associate member of ICSI. He is an independent director and IP professional registered with IBBI and a registered valuer. His experience spans over into corporate legal consultancy, financial planning, financial structuring, and corporate legal compliance advisory. He worked with prominent companies such as Pidilite Industries and Ford Industries, and had gained the various experience. Apart from that, Devang is also an academic contributor, having served as visiting faculty member of prestigious institutions like NMIMS, IES, and IPS, where he taught finance and business law. with this, and he's also partner of Mehta and Mehta Insolvency Restructuring and LLP.
Hello.
So with this, we can start our presentation. So we thank all our panelists for today's webinar for joining us on behalf of entire team of Mehta and Mehta. With this, I'll request Shrestha to start the presentation. Advocate Ayush, if you want to say a few words on the topic before.
Certainly, I'll pitch in. Not an issue.
You want to say a few words, or we can start the presentation, Ayush?
We can begin with this.
Yeah, okay, fine. As and when you want, yeah, please.
Certainly.
Shrestha, go to.
Just a minute, I'm starting with the presentation. I hope my PPT is visible to everyone.
Yeah, put it in a.
Right, yes. So let's start with the definition of corporate applicant as under section 5, subsection 5 of the insolvency.
Shrestha, your voice is not clear. Can you make it mic near or something? Some issue is there. Just.
Yes, is it clear now?
Yeah, that is better.
Okay. So the definition is actually quite broad. So it includes not only just a corporate debtor, but also a member or partner of the corporate debtor. It also, further, it involves individuals involved in managing operations or those who have control over financial affairs. Moving on to the second slide, we will now look upon the section 10, which is our topic of discussion today. So this is where the corporate applicant can initiate CIRP once a default has occurred. In simple terms, the company itself or an authorized person can approach the adjudicating authority to start the process. The application has to be properly filed with required details, especially financial information, a proposed resolution professional, and importantly, approval from the shareholders or partners. Once submitted, the authority has 14 days to decide. If there are any defects, the applicant gets a chance to fix them. And the key point is to remember that the insolvency process officially begins from the date the application has been submitted. Now coming to the next slide. Certain amendments have been proposed and it has not yet been notified. So there is certain changes in section 10 subsection 3 and also section 10 subsection 4, and there is an addition of a proviso. Everyone can have a look at it and I will explain it as well. In terms of changes, the overall structure remains the same. However, the bill introduces, it allows submission of any additional information as may be specified, giving more flexibility. Also, if adjudicating authority does not pass an order within the 14-day period, it is now required to record the reasons for the delay in writing.
Shrestha, go with a less slow speed. You are talking too fast. Go slow. Okay.
Okay, sure. So moving on to the next slide now, another amendment has been proposed. So under the section 16 of the Insolvency and Bankruptcy Code, specifically applicable to cases under section 10. In such situations, the adjudicating authority is required to refer the matter to the board for the recommendation of an insolvency professional who may now act as an interim resolution professional. So now I'm moving on to discuss a few case laws under section 10 of IBC. So the first case is State Bank of India versus Union of India, which was decided by the Supreme Court on 13 February 2026. So I'll give you a brief synopsis of the case first. So in this case, the issue revolved around the interaction between telecom law and insolvency law. The matter arose when companies from the Aircel Group initiated CIRP under Section 10 after defaulting on certain dues. A key question of the case was whether spectrum rights could be treated as an asset of the corporate debtor. While the financial creditors argued that it should form part of the insolvency estate, the government took the position that spectrum is a public resource held in trust and not owned by the company. The Supreme Court examined this conflict and clarified the legal position on the nature of spectrum in insolvency proceedings. Now, moving on to the next slide, I will discuss the facts of the case in a brief. The Aircel Group companies had telecom licenses granted by the Department of Telecommunication, and they had also acquired spectrum through government auctions. To run their operations, they took significant loans from lenders, including State Bank of India. Over time, however, they started defaulting, not just on the loan repayment, but also on license fees and spectrum usage charges owed to the government. Given this situation, they chose to initiate CIRP themselves under Section 10, and the NCLT admitted them into insolvency in the 2018. Later on, when the resolution plan was approved, it was challenged by the Department of Telecommunication, which is how the matter eventually reached the Supreme Court. Now let's discuss the issues of this case. The first question was whether telecom spectrum is a public resource held by the government or whether it can be treated as an asset of the company. Closely related to this was the question that whether the right to use spectrum under a license gives any kind of ownership or proprietary interest to telecom companies. Another important issue which was also upheld was whether this spectrum usage rights can be included in the insolvency estate and dealt with under the IBC. And finally, the court also examined whether companies can use insolvency proceedings as a way to avoid payments of license dues and other regulatory obligations owed to the government. Now, let's move on to the judgment declared by the court in this case. The Supreme Court held that telecom spectrum is a natural resource owned by the public, with the government acting as a trustee. It also clarified that companies only have a limited right to use spectrum, not ownership. Importantly, the court also ruled that spectrum cannot be treated as an asset under insolvency proceedings, even if it has been showed in the book. So it cannot be dealt with under the curriculum and framework of IBC, and the court largely upheld the government's position in this case. So that's all about this case. Now I'm moving on to the next case, which is of Union Bank of India versus Resolution Professional of KSL and Industry Limited. This is an order from the NCLAT Principal Bench at New Delhi, which was given in 8 December 2025. So again, I will start with a brief synopsis of the case. In this case, the issue was around the admissibility of a financial creditor's claim during CIRP, initiated under Section 10. The corporate debtor had entered insolvency as a corporate guarantor for loans given to other companies. The bank filed its claim, but it was rejected by the resolution professional on the ground that the guarantee had not been invoked. The decision was upheld by the NCLT, but later appeal was filed before the NCLAT. So that's why we are discussing this case now. So giving a brief review of the facts, the Union Bank of India had extended credit facilities to KSL Limited, and which acted as a corporate guarantor, even mortgaging its property to secure the loan. The loan accounts later turned into non-performing assets in November 2015, and subsequently CIRP was also initiated by KSL under Section 10. Following this, the bank filed its claim with the resolution professional. However, the claim was rejected on the ground that the guarantee had not been formally invoked. The bank challenged this before the NCLT, but the application was dismissed. Then the bank filed an appeal before the NCLAT. Now let's discuss the issues of this case. So the key issue here was whether a financial creditor can file a claim against a corporate guarantor without formally invoking the guarantee. Along with this, the tribunal also examined whether the resolution professional and NCLT were justified in rejecting the claim on that ground, and how the concepts of claim, debt, and the default should be understood under the IBC framework. The concern was also whether such rejection led to the creditor being wrongfully excluded from the Committee of Creditors, COC. Now,
Are you
coming to
putting
the
more light on it? Hello? Hello?
yes,
Ayush, can you throw some more light on this? Whether the guarantee can come in or not? That needs a certain
That's
technical explanation.
yes. So what happens is this Supreme Court judgment of China Development and Doha Bank has, of course, been one of a recent landmark position. And when you look into the claims definition, what happens, there's a difference in a debt and default when you're triggering a Section 7, and especially when you're only filing a claim with the RP. So in essence, when people look into the definition of claim, it also includes a very vast explanation. So it need not necessarily be invoked. Any claim which is a right of payment as well is also technically covered into it. And in fact, the judgment also goes to an extent which says that even if there's no direct disbursement, but there was a covenant to pay on behalf of the borrower, still it falls part within the Section 7 definition. So this judgment is critical and of an essence. It focuses more from a Section 7 perspective, but it definitely throws a critical interpretation of the definition of claim as per the code. So this has changed even from a legal standpoint in litigation. This judgment has been widely used by us as well. So it's worth reading in detail. The readers and the viewers may consider this judgment as part of their reading.
Yeah, because this is something very new development or something. Well,
Yes. Yes.
guarantee which is not asked for revocation, still you can apply to NCLT for it.
That's right. So for example, if there's a live BG, from a lender's perspective or a surety's perspective, it is not yet invoked, but suddenly you find that the corporate has gone under insolvency for a Section 10. So that doesn't take away your right from filing a claim. You would have not initiated a Section 7, because for initiating there needs to be a debt and a default.
It's applicable only for Section 10 or also for 7 and 9.
It affects, so when it comes to claim, everything gets covered. It can be initial Section 7, 9 or 10. So because then you are only filing a claim with the RP.
In the previous case where telecom regulation, other things were there, similar, what's your opinion for SRA for home buyers, where land is not actually given, but it's given on fulfilling a certain promise?
True.
So can you throw some light on that case of matter also?
See, in terms of home buyers, it's a very completely different scenario. Though in law, we are all aware that they
No,
are
no. In case of
treated
SRA, the land belongs to the SRA. Now somebody goes in a home buyers or something, a real estate thing. So you don't have the ownership of the land, or there's nothing. It's SRA. You fulfill a certain promise for a slum develop, and you get land in return to build something.
True.
So in case of SRA land rights, how you interpret it?
So from an SRS perspective, of course, the land is not owned by the CD. So that forms a critical part of your information memorandum. But when home buyers come into play, there will be an interplay between IBC and RERA laws as well. Technically, they will still be your they will sit in your COC because they have funded the corporate debtor. The corporator has effectively the developmental rights as its intangible. Now, we saw the first Supreme Court judgment on Aircel, which really dealt with the spectrum, where it was held that that is not part of the asset of the CD. It is more of a natural resource. And the state has it as a trust, holds it in trust. But when we look into Victory Iron judgment, which is another Supreme Court decision, it very clearly said that the developmental rights which a corporator will have, the land is not owned by the CD, but the developmental rights are part of the intangibles and asset of the CD. Correspondingly, the home buyers who have lent money, they have their allotment letter, so they fulfill their requirements as per RERA. So they fall under the category of your class of creditors. So the obligation on the CD to complete the project, to give them their units continues, while as an incoming resolution applicant, you may not have complete ownership on the land till that obligation is successfully complete. So they will have to.
Can
Maybe.
SRA take a different view from another commercial established home buyer? Suppose I have a property, land, and I give, and there's a SRA. So cannot be they treated differently or it's on the same footing?
So as far as home buyer is concerned, the treatment is going to
So
be the
not for
same.
home buyers.
But
Corporate data, ownership of the development right or the land.
so land, of course, is carved out. When you are taking from valuations perspective, for example, in the IBC, when you're appointing valuers, valuers are not going to give you the any quantum for the land because it's not owned by the city. They will quantify your developmental rights. And that is what you are going to offer under your information memorandum. But as far as the title is concerned, there will be a classification in your IM that there is an obligation on the CD and the land specifically is by the SRA authorities based on the obligations which any known resolution applicant will we cannot wriggle out of that contract. So
Okay.
effectively, if he wants to have it successfully implemented, he has to also abide by those other conditions. And like everyone's aware, there's also a clause for section 32 bracket E, which in essence says that the plan does not contravene with any other laws applicable. So effectively, they will also be bound to respect that obligations in place.
So both on a different footings, right?
Yes.
Okay, fine. Thank you.
Okay, so I'll continue with the order of this case. The NCLAT allowed the appeal and held that the invocation of guarantee is not necessary for admitting a claim. It clarified that while default is required to initiate CIRP, a claim can be filed based on a right to payment, even if it has not yet been invoked or matured. Accordingly, the tribunal directed that the bank's claim be reconsidered and admitted, restoring its participation in the insolvency process. So now moving on to the next case, we have the case of Trinity Auto Components Limited versus Axis Bank Limited. It's also from the NCLAT Principal Bench at New Delhi, and it's a case of 11 September 2025. So, giving you a brief synopsis, in this case, the dispute was around excess interest allegedly charged by the bank under an earlier BIFR rehabilitation scheme. The corporate debtor had already gone through CIRP under Section 10, and the resolution plan had also been improved for the same. The argument raised was that the benefits under the earlier rehabilitation scheme should still continue even after the resolution plan has already been passed. However, the NCLAT clarified that once a resolution plan is approved, it takes precedence over the prior arrangement. So now let's look upon the facts of the case. So Trinity Auto Components Limited was, as I mentioned, in a BIFR rehabilitation scheme which had reduced the interest payable to Axis Bank. But the company later claimed that the bank was still charging higher interest than it should have. Due to financial difficulties, it initiated CIRP under Section 10 and the resolution plan was eventually approved. Even after that, the company tried to rely on the earlier BIFR scheme to claim relief. The NCLT only partly accepted this, which is why the matter went on to appeal before the NCLAT. So, I'll discuss the issues of the case now. The main issue here was whether the corporate debtor could still claim benefits under the old BIFR scheme after the resolution plan had already been approved under IBC. It also raised the question of whether pre-CIRP claims, especially those which are not included in the resolution plan, can be enforced. Also, the third question was whether the approval of resolution plan under section 31 of the IBC extinguishes pre-CIRP claims arising from the prior statutory regime. So now let's look upon the order. So the NCLAT made it clear that once a resolution plan is approved, it becomes binding on all stakeholders. Applying the clean slate principle, the tribunal held that any claims not part of the plan stand extinguished. So the earlier BIFR scheme does not survive unless specifically included in the plan. Accordingly, the appeal was dismissed with only limited relief allowed as per resolution.
Trista, you have to be speeding up and, let the synopsis only work, facts in two
So
lines.
now,
Yeah, otherwise we
sorry.
will not able to wrap up. It's already half an hour, 5:29. Okay,
Okay, so should I pace it up a bit?
sorry.
Should I slow down?
No, not slow down. That, the order you need not say, people are reading. So, facts and the synopsis, that's all.
Oh, okay,
Facts
sure.
issues, because people can read it out. Otherwise, we will not able to finish it. Okay.
Okay, sure, sure. So the next case is that of Amit Agarwal, a suspended director of Sundaram Mahadev Auto World versus the erstwhile resolution professional of Sundaram Mahadev Auto World. It is also from the NCLAT New Delhi under case of 21st March 2025. So giving a brief synopsis. In this case, we have a suspended director who challenged the admission of Section 10 application under the IBC. Basically, the company itself had filed this application to start the corporate insolvency resolution process. The director argued that the application wasn't properly authorized and had some defects. Then CLAT looked into whether all the legal requirements for filing the application were met and whether a suspended director's objections could stop the process. The tribunal made it clear once the authority is satisfied that there's a genuine default and the application is complete, the CIRP can go ahead. So, in simple terms, the director's challenge did not hold up and the insolvency process continued as planned. So, I'll just discuss with you the facts of this case. As I already mentioned, the Section 10 application was filed and everything. They backed it up with documents showing financial distress and default. The NCLT went through the application and the documents and found that all the requirements under Section 10 were satisfied. So they admitted it and the CIRP began. So subsequently, once that happened, the management of the company was suspended and an interim resolution professional was appointed to take charge. Now, a suspended director filed the case before NCLAT, claiming there were procedural irregularities and questioned whether the company was even allowed to file the Section 10 application in the first place. Essentially, the appeal was asking the tribunal to set aside the NCLT's order that had admitted the CIRP. So you can have a look at the judgment and issues I have already discussed in brief in the synopsis. And once everyone is done, I will move on to the next case.
Yeah, go to next.
Okay. So the next case is that of Srishti Infrastructure Development Corporation Limited versus Housing and Urban Development Corporation Limited. This matter was also heard by the NCLAT Principal Bench at New Delhi and it's a case on 25th March 2025. So in this case, the corporate debtor questioned whether the application itself was maintainable and even whether there was any actual default. The NCLAT looked closely at whether the adjudicating authority had followed the law correctly under the IBC before admitting the application. The tribunal emphasized that once the application is complete and the default is established, the NCLT is obliged to admit it and start the CIRP. After reviewing the facts, the appellate tribunal found no legal flaws in the NCLT's order. They also made it clear that the objections raised by the appellant could not affect the validity of the insolvency proceeding. Essentially, the process was proper and had to continue as per the law. So now going on to the facts of the case. The applicant claimed that the corporate debtor had defaulted on repayment of its financial dues. The NCLT carefully examined the records and was satisfied that the default had indeed occurred. Based on that, the application was admitted and the CIRP started, and the interim resolution professional was also appointed to manage the process. However, the corporate debtor challenged this admission before the NCLAT. They argued that the application wasn't maintainable and even questioned whether the debt and default existed at all. Essentially, the appeal was asking the tribunal to set aside NCLT's order and that had initiated the CIRP. Everyone can have a look at the issues and order of the case, and then I'll move on to the next slide, discussing the next case.
You can move on, Shrestha. If anyone require, they will give comments, okay?
Okay, sure. So the next case is that of Jacodia Trexine Private Limited, which was heard by the NCLT New Delhi. The order was delivered on 19 January 2026. So in this case, the corporate debtor filed a Section 10 application seeking to start the CIRP process because it was again unable to repay dues owed to the HDFC Bank. However, the financial creditor opposed the application, claiming that it was filed with malicious intent to stall recovery proceedings that were already underway before the debt recovery tribunal and under SURFACE action. The NCLT had to decide whether this was a genuine attempt at insolvency resolution or an abuse of the IBC process. After reviewing the facts, the tribunal concluded that the petition was filed with an ulterior motive to take advantage of the moratorium and delay recovery. As a result, the application was rejected. Now moving on to the facts of the case. The corporate debtor took loans from HDFC Bank in 2012, secured by property and personal guarantees. The account became an NPA in 2016, and the bank started recovery proceedings under SURFACE and the DRT. Despite this, the debtor filed a Section 10 application under the IBC to initiate CIRP. The bank opposed it, arguing that the petition was filed just to stall recovery and take advantage of the moratorium. So that's about the case. Here are the issues and orders, and I'll move upon to the next case.
In case of surfacing IBC, what would prevail?
Excuse me.
Hello?
Hello.
Yes. Yes.
Between IBC and surfacing, which would prevail?
There is a case law, no? Recently only. That even though for attachment, actually.
Okay.
Ayush, your comment?
Ayush, your comments?
See, between SURFACE and IBC, what happens is once the petitions are in play, so IBC does supersede effectively. And we have seen, positions where if it's a genuine petition, of course, we've also had cases where it is non-genuine, then SURFACE has been upheld. But if the IBC parameters are met, then in that sense, it does take precedence based on Section 238 as well.
Okay, thank you.
Yes, sir.
Okay. So moving on to the next case, we have Metcalf Properties Private Limited by NCLT New Delhi from 3rd December 2025. So Ms. Metcalf Properties, a real estate company incorporated in 2002, filed a Section 10 application due to defaults. The key default included over rupees 34 crores owed to the Amritsar Development Authority for development charges and license fees, as well as rupees 1.2 crores in income tax dues for 2015 to 2016 year. The NCLT admitted the application and interim resolution professional was appointed, and it declared a moratorium under Section 14 and directed the company to publicly announce the proceedings and submit details of the creditors. So the facts has already mentioned that there was a default in payment of 34.65 crores and the additional income tax liability of 1.19 crores, and the financial statements and records are placed on record. Company admitted ability to pay debts, so that's why the case went before NCLT. And Yeah, here are
Krishna,
the
keep your mic clear. Your voice is not coming out properly. Keep near to your mouth.
is it okay now?
Yeah. Be careful.
Okay, so these are the issues and order of the case. And I'll move on to the next case. The next case we have is that of Exotic Buildcon Private Limited, again by NCLT Principal Bench in New Delhi, and it's from 10th January 2025. In this case, Exotic Buildcon Private Limited filed a Section 10 petition under the IBC to initiate CIRP, citing financial distress and defaults exceeding rupees 1 crore. The company mentioned factors like economic slowdown, GST transition, demonetization, and COVID-19 as reasons for its crisis. Initially, the tribunal had concerns about non-disclosure of material facts, pending execution proceedings, and whether creditors had been properly served. After giving the company multiple opportunities to comply with directions, including filing affidavits and rejoinders, the tribunal was satisfied that debt and default existed. The application was complete and admitted the petition. So, moving on to the facts, the total default was of around rupees 10 crore, rupees 10.78 crores owed to financial, operational, and statutory creditors. Exotic Buildcon operates in construction, real estate development, and property management. Initially, the tribunal also noted some defects like incomplete disclosures and lack of proof of service to the creditors. There were also pending execution proceedings before the Rohini Court and tax notices under Income Tax, HVAT, and CST Act. Allegations of bogus transactions were raised by tax authorities. The company later submitted affidavits and rejoinders, which cleared all of that. So here are the issues of the case, and this is the order. And moving on to the next case, we have Parquet Furnishers Private Limited, which was heard by the NCLT New Delhi bench on 14 November 225. So, giving you a brief synopsis of the case, in this case, the Parquet Furnishers filed a Section 10 application admitting financial default. The NCLT emphasized that once debt and default are established and the application is complete, it must be admitted. The tribunal rejected objections about limitation and parallel proceeding, declared a moratorium, and appointed the IRP proposed by the financial creditor. This shows how strictly tribunal follows the statutory requirements under the IBC. So moving on to the facts, Parquet Furnishers has been in the wood and flooring business since 1995. They took loans from the Bank of Maharashtra but defaulted due to financial stress, and the account became an NPA in 2014. Recovery actions were initiated, including asset auctions, but about rupees 7.79 crores remained unpaid. The company stopped operations and couldn't revive the business, so they filed a Section 10 application with shareholder approval. The financial creditor accepted the debt and agreed to the CIRP. So I have discussed the issues and judgment of the case in brief during the synopsis, and moving on to the next case. So
Well,
the next case,
there is a question. What are good motive for initial CRP under Section 10? Mr. Rajesh Gupta. Ayush, you would like to comment?
Yes, certainly. It's a good question and a difficult one in that sense, but actually, there's no straight jacket answer to that. But effectively, what we have observed that bench considers there, something like a proximity of time. So, for example, if the bankers are on the auction notices have been issued, the possession is already taken, and it is about to get concluded, and if then all of a sudden the company approaches the bench with a Section 10 petition, then they do not restrict themselves only with the paperwork. They also consider the surrounding reasons as to why at this point would a company come under, would come under a Section 10 trying to trigger. The motive, if I may say so, is that the good motive is as far as you are able to prove that it is not to scuffle surfacey proceedings, or any sorts of attachment or stall any auctions by the lenders. And on the other hand, if there are no lenders, there are companies which really do not have any funding from financial institutions, but then they try to evade income tax, GST, and such other statutory liabilities, then that is also something which the bench does consider, that if the accounts have been attached by income tax, there are notices issued, things like that, then it is treated as not a good intent. But having said that, if you are able to satisfy that it has not gone that bad and that far, and the intention was never to scuffle those proceedings, in fact, it's an attempt to try and revive, and whatever possible can be paid off to the statutory authorities or the lenders is what they really look into. So under law or per se, there are no judgments which qualify or define good intention, but it is more of proximity of time and the surrounding liabilities that revolve, around the company's status when they are filing this petition. So that is something which is a key, not merely the form and the paperwork that happens. That is one part of it. The other part is the clear intent and the position at which the company stands as we speak, in that sense. So it's a very subjective and it's different from every case to case. We've seen section 10s getting dismissed. We've seen section 10 getting admitted as well. So it's an interesting section.
Thank you. Yes, sister, go ahead. Shrestha, go ahead. Just name the company name and straight away go to the facts and synopsis.
Okay, so the next case is of Aryan Castings Private Limited by NCLT Mumbai bench. So the brief synopsis of the case is that the Aryan Castings had multiple loans from Union Bank totaling around rupees 25 crores plus an extra loan during COVID-19. Due to ongoing financial stress, the company defaulted and about 31.74 crores remained unpaid despite SURFACE proceedings and asset auctions. The NCLT emphasized that once debt and default are established and the application is complete, the tribunal must admit it. Now, moving on to the next case, we have Vasantrai Bottlers Private Limited by NCLT Chandigarh bench, delivered on 20th February 2026. In this case, the NCLT emphasized again that once debt and default are established and the application is complete, it must be admitted. In this case, the Vasantrai Bottlers, the company, had taken a long-term loan and working capital loan from a bank. While the term loan was repaid, the working capital loan defaulted and the account became an NPA in 2019. The company's financial statements confirmed ongoing liabilities and the creditor had initiated SURFACE proceedings. Shareholders approved filing a Section 10 application, which included the IRP's consent and all required documents. So now moving on to the next case, we have Unimate Services Private Limited, judgment by NCLT Bangalore bench from 12th January 2026. In this case, a Section 10 application was filed. The NCLT found that debt and default existed and that all statutory requirements were met. The tribunal emphasized that once its conditions are satisfied under IBC, the admission is mandatory. Hence, a CIRP was initiated and the moratorium was also declared. So basically, Unimate Services faced financial crisis and couldn't repay debts totaling around rupees 1.35 crores. They had multiple financial and operational creditors and notices were sent with no objections received. Financial statements showed continuous losses and shareholders passed a special resolution to initiate CIRP. That's why the case went on to NCLT Bangalore. The next case is that of Roofco Trading Company Private Limited, which was heard by NCLT Kochi bench and delivered on 2nd December 2025. In this case, Roofco Trading Company filed a Section 10 application. The NCLT found that the company had defaulted above the statutory threshold and that all procedural requirements were met. The tribunal emphasized that once debt, default, and completeness of the application established, admission is mandatory. CIRP was initiated and the moratorium was also declared.
Dear, this is straightforward case, so need not be established or mentioned. It's just the admission. So you go ahead, no issue to need to
Okay.
say anything.
Okay.
If any
So,
issue is there, you say. Okay.
okay. So the next, should I tell the issues of the case?
Yeah, means if there is issue, then you, because in your
So the
synopsis,
issues were basically the same only as the last case. It's a similar case only.
Hmm.
So I'll move on to the next case. The next case is that of RKKR Steels Private Limited, which was delivered by the NCLT Chennai bench on 21st November 2025. In this case, even though there were objections alleging fraud and suppression of facts, NCLT found that debt and default were clearly established, and the allegations under Section 65 were unsubstantiated. So the RKKR Steels had defaulted on financial and operational debts exceeding rupees 50 crores. Its liability to Surana Industries was even confirmed by the Supreme Court. Surface proceedings were also initiated. While some liabilities were initially not reflected in financial statements, the board passed a special resolution to initiate CIRP, and objector alleged fraud, misstatements, and malicious intent, but the corporate debtor maintained that it genuinely couldn't pay its debt. This set the stage for tribunal to examine the validity of the Section 10 application. So next I will discuss a few IBBI disciplinary committee orders of February and March 2026. The first order is of 19 February 2026. The IBBI found that the IRP accepted and undertook a CIRP assignment without a valid authorization for assignment. His AFA had expired on 8 November 2024, and yet he went ahead with the appointment. He issued the public announcement despite not being authorized and failed to inform the adjudicating authority within 5 days about the AFA expiry. These actions violated Section 208, subsection 2 of the IBC, and Regulation 7A of the IP regulation, which governs professional conduct and eligibility to undertake assignments. So, in the submissions, the insolvency professional admitted that issuing the public announcement without a valid AFA was a bona fide mistake and an error of the judgment. He explained that he had sought clarification from his insolvency professional agency but did not receive a timely response. He proceeded to avoid delays in the CIRP and did not gain any financial benefit from the assignment. So the IBBI Disciplinary Committee carefully examined the sequence of events, relevant regulations and communications between the insolvency professional and his agency. They noted that the AFA had already expired before the CIRP began, yet the professional issued the public announcement and failed to promptly inform the adjudicating authority as directed. The committee concluded that under the applicable regulations, he was ineligible to undertake the assignment at that time. As a result, it held that statutory and regulatory contraventions were clearly established. Finally, the IBBI concluded that the professional has violated the provisions of IBC and IP regulations by accepting the assignment and issuing the public announcement without a valid AFA. So the next order is from 24th February 2026. So the IBBI disciplinary committee found that the insolvency professional has acted beyond his authority during the CIRP. He improperly handled the constitution and reconstitution of the committee of creditors. He also filed misleading interlocutory applications and contradictory affidavits without disclosing prior filings. The committee also raised concerns about transparency in this case. In the submissions, the insolvency professional explained that many of his actions during the CIRP happened under complex circumstances, including undergoing multiple litigations before NCLT and CLAT and even the Supreme Court. He said the withdrawal application and related steps were promptly by settlement discussions and directions from the adjudicating authorities. Regarding the alleged backdating of a letter, he explained that it was drafted earlier. He also emphasized that no stakeholders were prejudiced and that the CIRP continued according to timelines and procedural requirements. So, after reviewing the investigation reports and everything, the disciplinary committee highlighted that insolvency professionals hold a position of high public trust and should maintain complete transparency, especially in court filings. The committee found that submitting a withdrawal application without prior COC approval clearly violated statutory requirements. Filing contradictory affidavits and withholding material information also misheard the authority. Considering the seriousness of the violations, including improper reconstitution of the COC and everything, the committee suspended the professional's registration for 3 years. The order takes effect after 30 days, and the copies were sent to the NCLT and other stakeholders in CIRP. So the next order is of 26 February 2026. In this case, the insolvency professional continued operating the CIRP bank account and carrying out financial transactions even after liquidation order had been passed. Essentially, he had acted beyond his authority at that time. The professional explained that these actions were carried out in good faith, claiming they were administrative and intended to protect the CIRP and stakeholders. He emphasized that there was no intention to breach any legal framework and provided context about why the account operations and payments were made. After reviewing the investigation and the insolvency professional submissions, the disciplinary committee emphasized that professionals must act strictly within the authority granted to them under the IBC. So, as a result, the professional's registration was cancelled for 2 years. So, the next order is from 18th March 2026. In this case, the insolvency professional failed to comply with explicit directions from the adjudicating authority, which required him to personally appear and file an affidavit explaining his absence. He missed the hearing on 5th March 2025 and did not comply in time before the next hearing on 24th March. The board viewed this as negligence and contributing to delays in CIRP, including the pending resolution plan. In his submissions, the professional explained that the absence was due to miscommunication and that he later appeared on 24th March and filed the affidavit on 25th March, which was also accepted. He also cited another mandatory court appearance on 19th May under Section 138 of NI Act and stressed that the delays were partly due to limited time before the tribunal and not intentional non-compliance. So, after reviewing the CIRP timeline, filings, and orders, the disciplinary committee found that relying on counsel's mistake wasn't sufficient. The professional also did, especially since the hearing date was publicly available, the professional also did not ensure timely compliance with the order before the next hearing. Although his absence on 19th May due to a court summons was accepted, the committee concluded that the non-compliance was established and issued a warning to exercise greater diligence in future. The penalty of rupees 25,000 was imposed and to be deposited to the Constituted Fund of India within 45 days. So that's all with the cases and the disciplinary orders from my end.
Okay, thank you, Shrestha. There is two questions, not on the topic, Ayush. It is one thing is that there is only one time extension, then how CIRP run up to 900 days? Could you explain?
So, no. So this is a situation. So of course, one time extension under section 12(2) is basically for your 90 days extension, which is from 180 to 270. Now, what happens is in most of these cases, it is not practically possible to conclude the CRP process And hence, based on our landmark decision of SR Steel, we keep going back to the bench. First, we place an agenda before the COC, because by then, and what we've experienced is, you only have certain PRAs in the process. The resolution plans have not yet come through. RPs also face difficulty in terms of completing the information memorandum, the valuations, as well as the transaction audit due to complete lack of information from the suspended management. So based on these factors, every time you need some more time, we have to go back to the COC first. Once they approve an extension, we try and explain the honorable adjudicating authority that in this particular case, the reason why it could not be completed in 270 days because of these. There are situations where the resolution applicants also need some more time to analyze the company and give you resolution plans. And hence, we time and again go back to the bench. Once they are convinced on the facts, they have the power to extend the timelines. Now, when it goes substantially beyond for an incredibly about 400 days, 450 days, which typically is seen more in a real estate sector because of the complications and the numerous litigations that come into the play. Considering all of it, there are, I would say, at least 7, 8 out of 10 matters would easily exceed 330 days, ranging from 330 till as many as 700, 800 days. So these are fact specific. NCLT does have the power to extend it. Having said that, there are also cases where the bench is not convinced on an extension and they do ask the RP to file for liquidation, because if they feel that the COC is just taking things for granted on a slow pace and they expect that every time a COC approves extension, the bench is obliged to give it to them, then it doesn't happen that way. But this is a situation, and we have seen extensions. It all depends on the facts of each of the case, and benches do consider it, especially when it is home buyers or a real estate segment into question.
The second question is, if auditor is appointed under IBC, then what is the period he should audit? Or it should be normal period April to March?
So again, typically there are two things. One, if you are continuing with the same statutory auditor who was also auditing pre-CIRP, that is something first you need approvals from the COC in terms of whether to change the auditor or no. Coming back to the standard requirement that an auditor continues till the next AGM, in this case, it's effectively taken approvals in the COC itself. And we've seen that if the last audited balance sheet, for instance, is way back of 2021-22, and he has to do about 3 to 4 years of audits, then typically that tenure is more from a perspective of giving them a complete scope of work, that they'll have to complete all these audits, hand it over to the RP, and that is where it ends. So he is responsible to the extent the scope of work is decided between the RP and the COC. Sometimes you just want a 1 year's balance sheet, then you analyze it if the auditor is able to cope up, or you may want to change. So it all depends predominantly on the COC's decision. And also the key question whether you are continuing with the same auditor because of his experience and the information that he has about the company, or if you're going to switch the auditors. But as far as the tenure is concerned, he'll be responsible based on your scope of work. And it will continue till your resolution plan approval order comes into play, because it is at that point in time when the RPs are also supposed to hand over a balance sheet to the incoming new management. So that these scopes are decided internally in the minutes.
Then if there is not proper maintenance of books of account, then what should auditor report and who is responsible for the same?
So in this case, again, we fall back to our good old section 19.2 for non-cooperation. Because if we do not have the tally data, auditor can't really do much. The only way of looking into it is trying to pull out the bank statements, and you try to reinstate the books only based on the debits and the credits. And more likely than not, what happens, the narrations are not sufficient enough to identify the parties or the purpose for which is made. So typically these balance sheets are just seen as opening closing balances, except for the CRP cost that gets incurred, which can be actually documented. Otherwise, it's a very, I would say, an open-ended balance sheet. In terms of responsibility, there are enclad judgments which says that it is the responsibility of the suspended management to hand over an audited balance sheet as on the insolvency commencement date to the RP along with all the details. But it is easier said than done. We've seen constant resistance from the management that tally data I don't have, computers have crashed. I have given to a chartered accountant whose fees are not paid, so he is not willing to cooperate. So we see all these permutation combinations. But
Yes, sir.
responsibility per se is shifted to the suspended management.
And the next question is, it is good to continue to existing auditor or need to change?
Now, again, being a CA myself, I would say that everything depends, of course, on the integrity. If you have a good firm who's already auditing it, there are no red flags in terms of, they assisting the suspend management in any sort of connivance. I do not see any reason why you need to change. But from a COC's perspective, we've seen a general tendency that they want to change the auditors just so that if there are any missing links, an incoming auditor will, with a fresh pair of eyes and a fresh thought process, may be able to dig out and identify any flaws in the accounts or the bookkeeping practices of the corporate data. But there is no per se a legal requirement as such as a mandatory need to replace auditors. We've seen auditors who've continued, they have their own reputation, they have their own respect. In fact, most of them are also on the IBA panels of the banks also. So when that matches, it is convenient for RP also to, to cooperate with them, and the auditors are also then willing to extend their tenure and their engagement. So it's always advisable to have the existing person unless there is a scare of having some sort of a connivance or some sort of an control by the suspend management on the auditor. But it's typically fair enough to continue with the existing firm.
Okay, thanks.
Thank
अरे
you.
बाप रे, Sanjay Jha is there. अच्छा, this is Sanjay Jha. RERA imposed penalty for non-registration of project. Now company under CIRP. Is RERA penalty payable by RP?
Now again, so of course, I mean, if it is now getting registered, the non-registration kicks in within the CRP period, then there is always a question that whether it forms part of your CRP cost and whether you need to reinstate that. But so that will, in essence, forms part of the CRP cost because this is a critical aspect, both from a home buyer's perspective to give them their due share of seat on the COC, as well as the information memorandum, so that when the resolution applicant comes in, you can also pitch in as a ready project. And as the viewers will be aware, there is also a regulation which, in fact, for real estate sector, requires an RP to have a marketing strategy. Now, this becomes a crucial aspect. If you have a valid RERA registration, you will attract more investors, you will attract better value for home buyers, and home buyers will pursue these proceedings as beneficial. They would respect the decisions of the RP and the authorized representatives. But this cost, there will be resistance from the COC if it's the banks and the financial institutions, that why would a non-compliance of a suspend management should be borne by us? Let it be the way it is and let the SRA come and deal with that. So we've seen that as well. Sometimes the penalties are pretty substantial. So it may not be even be viable financially to have to have it
But so that
reinstated.
if permission is not granted, how it can be proceed further? That's the
Correct.
question also.
Correct, correct. So that is where again the ball stops, and the only thing the RP can do is declare in the information memorandum and let the incoming RA deal with it subsequently.
COC says it is only 6-9 months. I will hand over. Why I will do in 6 months?
That
Also,
won't
कौन सा
happen.
building बन जाने वाला है?
Like in certain cases, the construction is going on and RP is managing the construction, there's a problem.
Then there's a problem.
If
If
the
it's
work
a
is stopped,
running, yes.
nothing happens.
If it's a running project, we'll have to take care. In fact, there are judgments which also says the RP is also supposed to conclude the conveyance and sale deeds. So there
Yeah.
are. It all depends on that project and the stage at what it is.
Yeah.
So running a construction ongoing is a much difficult job than
Certainly.
getting the project stopped.
Yeah, it's like that only, like CRP of running company and CRP of closed company.
Now here,
Difference.
in real estate, it's a major issue because RERA is predominantly still exist.
Yeah, any running company is a issue actually. A running
Yes, absolutely.
closed is fine. Okay, friends, I think we have answered all the questions. Thanks, Ayush, for your time. Thanks a lot and sharing your experience and knowledge with the participants. Thanks a lot.
Thank you so much. Appreciate the opportunity. Thank you for having me. Thank you, everyone.
Thank you.
Thank you.
Thank you. Thank
Good
you.
evening. Thanks.
Thank
Thanks.
you, Krisha.